this is going to be taped for immortality, right?
Yes, it's going to
And
be
so what we do is we
available on
go for the
YouTube.
immediate and for the long-term audience. And what happened is it was Aurelio who managed to come up with this title about what was the name of this principle again?
Precautionary.
The precautionary principle, yeah,
Right.
and how it works. And we've heard people start to say that what happens is it may work with respect to the environmental world, but it certainly doesn't work with respect to the IP world. I think that's correct on the second half, but I think it's also wrong on the first half. And let me see if I can explain why it is that you don't want to use a precautionary principle anyhow, and then to try to figure out the narrower question, which is what is the relationship between injunctions or administrative orders that prohibit or require certain conduct, and either injunction or private actions for damages or public actions for fines and so forth, where you really do want to put the situation. So essentially, if you want to start off with the particular situation, the usual model that people did before they invoked something known as the precautionary principle was to say that what you try to do when you're dealing with these things is to first give yourself a appropriate goal that you wish to have, some form of maximization of social utility, which in the patent space would come down to the situation. You want the highest level of innovation, consumer surplus, or whatever. Okay, so that's what's going on. And then what you try to do is to figure out what the errors are going to be on both ways. And you do a straight expected value analysis. You try to take into account the probabilities of the loss on one side, and then try to figure out the extent of the damages given the losses. You can make these equations as much as you want in terms of complexity. And then you do exactly the same thing on the other side of the equation when it comes to the benefit side. And what you try to do is to come up with an expected value calculation. And if you use this particular model, what happens is there's a certain tendency on your part to realize that you have to make realistic expectations on both probabilities and consequences in both directions. Certainly if it's your own business, because what happens is you make the wrong ones, you are going to make some kind of a mistake. But then when you start coming to the precautionary principle, what they're trying to say is if you start to look at one particular side of this particular equation, it turns out that there's a discontinuity at some undefined edge, and that's going to lead to the end of the universe or something of the sort. Whereas if you go on the other side, you don't have that precipice or that cliff, and so you don't have to worry about that question. And so essentially now the model is not how you maximize expected utility. It's a question of how it is you manage to avoid falling off the edge of the earth. One of the examples that were given was essentially the problem with respect to GMOs. And the theory is that somebody can invent a Frankenstein type species that comes out there, which consumes everything on the face of the globe and manages to eat everything up. Well, I mean, the first question you want to look is just how are you going to make that claim work, even in the environmental area? And it turns out that what happens is the most important feature to understand about GMOs is that they're standardized products, heavily tested, dealing with only a specific interaction of genes. And since you're doing repetitive processes and you look at it, the probability of coming up with something that's going to be crazy is going to be extraordinarily low because the way the technology goes is avoids this. And indeed, if you understand that if you do come up with a GMO that is essentially disastrous, it's going to ruin the very people who buy it. So you get some private incentives as well as some scientific knowledge, all pointing in the same direction. So then you start looking at the other side at various countries. And what you discover is that many companies are really on the margin in terms of their ability to feed their own populations. Things have gotten much better in this regard over the last 20 or 30 years, almost invariably because of technological innovations, including generic GMO drugs. And why are they very good? Because what happens is they now can guard against specific kinds of defects that can decimate crops and so forth, so that the yields that you're going to get are systematically higher. So if you want to apply the precautionary principle, the first question you have to ask is, which tail is the tail which actually has the precautionary risk that you have to deal with? And the traditional anti-GMO account puts it in the wrong direction. It assumes that the losses that you get from GMOs are going to create that kind of system, where in many cases, it turns out it's the losses on the other side that are going to do this. If you want another historical example in the environmental area, anybody should follow the trace of the implication of the use of DDT with respect to control against various kinds of infection. And there's a great book about this written 50 years after the silent speech by my friend Andy Morris and a couple of other guys, miners in Le Rocher, in which they go through the way the world looked before you had DBT and the mass influences of dengue disease, hundreds of other conditions, malaria and so forth. This thing, in fact, managed with very, very low side effects to prevent huge numbers of losses, far more by these applications than you could ever do by medicine, which takes place intensively only after the injuries take place. So it's a losing strategy relevant to this. And Rachel Carson then identifies some eggshell that may or may not be thinned by the use of the DBT, and we ban it worldwide. And so you're trying to talk about a real catastrophe. The setbacks that took place with respect to the feeding of the world and the control of diseases to this day, which is now 60 years after the Silent Spring came out, there is still no perfect equivalent that's as good as DDT. And what you're doing is, therefore, when you play this game, again, these things go in both directions. So when you start coming to the antitrust law, it's exactly the same kind of question. I agree that nobody can identify a wrong situation at either tail, so that the principle, i.e. the precautionary principle, which fails as an operative matter in the environmental area, can succeed in this particular area where you can't even give the doomsday scenarios. And it turns out that if you wanted to play the game, exactly the same kind of argument could be made. If you block certain kinds of mergers that allow a new technology to reach rapidly and diffuse throughout a population, you may consign millions upon millions of people to isolation because they cannot communicate. Does that count as a disaster? For which means that we have to allow for more merger vis-a-vis the other situation. And I actually do have a strong prior on this, and I think it's the ones that other people in this room have, which is namely, I think that if you're talking about long-term systematic effects, the dangers of market restrictions are in the standard models of monopoly. It costs you roughly 15% of price changes, which may yield to a 10 to 15% loss in productivity. You're talking about billions of dollars. This is real money. But if on the other hand, you basically stop a technology that's worth trying to improve and try to figure out what the cost of that is, what you just have to do is to sort of figure out what the consumer surplus is under any of the curves that are associated with the great inventions, whether it be the transistor or the vacuum tube or anything else that you start to want to talk about. And on the production side, the idea that the only kind of improvement that you could get from improved production is in the order of 15 to 20% is just bizarre. Every single case that people have talked about, what you're doing is you're talking about 100-fold or more increases in consumer welfare by the spread of these kinds of properties. And all you have to do in order to figure this out is to sort of try to get a curve that looks at the consumer surplus under the protection of any standardized commodity that we have today. And we know how we can figure this out. What you do is you take these commodities, standardized for ability, and figure out what the purchase levels were 20 years ago, then 10 years ago, and 5 years ago. And what turns out is, even when you raise the cost of these technologies by 5 or 10-fold, there's still going to be a real market, because we've done more than that when it comes to all the computer stuff, if I'm not mistaken, since the 1980s. Well, that in effect gives you the shape of the consumer surplus curve. And what you're talking about here are enormous gains. So what you're doing, if you try to do a primitive quantification, is relatively modest but significant losses from monopolization, if it happens, as opposed to huge technological losses, which you can't recover anyhow, if it turns out that you start to get these things wrong. So I think that the first thing you want to do when you apply that principle is to just take that fundamental asymmetry, which indicates why it is that the sort of precautionary principle does not translate into greater relief. The precautionary principle, if you're going to apply something like it, translates into the other side. Try to go for the productive gains relative to the monopoly risk. So then in a world in which all of these things are taking place, the question is, how do we then try to develop our particular strategy? And first thing to know about the antitrust law is it is not unique in any way, shape, or form relative to any other discipline that has to worry about this question. The obvious way to do this, if you start looking at all the recent case law on this particular stuff, you discover that the exact same kind of trade-offs that we do here are done in consumer fraud cases. where they're trying to figure out, like in the AMG case, whether you can get injunctive relief, right? And can you add damages to it? That was not an antitrust case, as I recall, right? It was a consumer fraud case, if I got it correct. Isn't that right, that you, I think I got something right. Well, if that's the situation that's there, well, you have to figure out what the way in which this thing starts to work. And here's a kind of a sensible way. Start with the simplest tort cases going back 500 years. And the question that you're starting to worry about is what's the relationship between injunctive relief, damages and fines and so forth. And the older folks had the following basic principle. If there is a blockage of a road or pollution of the river, the first order of business is to remove the obstacle, just the way in this area, the first order of business is to perform the deal. And so what you could do is you have a judicial enforcement of a remedy, which does one of two things. It either removes a blockade from a road, or it actually tries to eliminate the pollution from a river. Do you want to allow any private actions with respect to these diffuse harms? The answer is no, because the transactions costs are overly prohibited. But there is a small class of cases known as special damage cases, where people who are uniquely injured in a particular area should be allowed to get damages. And those were essentially if you ran into a blockade on the road, or if the pollution in fact poisoned you when you were on the river, you can start to do those things. And I think that's a perfectly sensible way in which to do it. And when it comes to the antitrust laws, I think you probably want to engage in the same principle. What's interesting about the antitrust laws, though, is that for the most part, these are structural harms that you're talking about. And if it turns out that the structural harms that you're talking about, and you're talking about general price diffusion as being the kind of problem, the answer, I think, by and large, is that you wouldn't want to give special damages. One of the recent experiments that we've seen, which was also at stake in the AMG case and a bunch of other cases that have come up, is somebody says, well, the way we solve that problem is to create a system in which we allow class actions to pick up the slack. It turns out, I think, that the administrative complications associated with the class action, putting it together, trying to figure out what the damages are, in many cases where the losses may just be probabilistic or intangible, like somebody has now have the unauthorized possession of your particular data, and we don't know whether they're going to release it to a third party or keep it to themselves. Those things start to create as many administrative difficulties as possible. So the way in which I tend to think about these particular cases is follows. First order of business is if there is an abuse, figure out how you structurally stop it. And in some of these cases, it'd be very simple kinds of solutions that are appropriate. If there's a certain kind of cooperation agreement of a horizontal nature between two firms, what you try to do is to enjoin its enforcement and say you guys can't talk to one another anymore in order to restore the competition. But I'm not sure that you want to do much more than that. And so what often happens is one of the advantages of the simple injunction is it gives you a much clearer shot at trying to figure out what it is you're trying to stop and how you're trying to do it. And it allows you to adjudicate very difficult issues under circumstances where, since you're doing it very early on in the process and there's no huge class action or damage component, you could get a decent rule. So I'm just going to mention one case that I've always kind of admired, not because of the outcome, but because of the process. In the early days, one of the major antitrust cases we had was a case called Fashion Originators. I don't know if people remember that case. And what it involved was a very peculiar kind of collective agreement. It turned out that all the reputable manufacturers of various kinds of garments and clothes, they had styles for a season. And these were not subject to any patent protection or any other intellectual property protection. And so people could essentially knock them off. And everybody understood that this was a diversion of labor. The same rationales apply. I invent the way in which you put this technology together. You use it without a license and free of charge. So the innovator is now at a systematic disadvantage as against the theft thing. And so what these guys did is they had an antitrust agreement which says we will not sell our products to anybody who's pirated these goods. And so it wasn't an effort to fix prices. It wasn't an effort to do anything except to try to combat that thing. The nice feature about the case was that if you do this in the form of an FTC enforcement, you get a very clean view of the legal issue, which is, can you say that a collective refusal to deal based upon the anti-piracy principle is going to be protected? Now, in that particular case, Justice Black came up with the answer, no protection. It's either done by the statute, it's not done by all. Reasonable people, I think, can disagree with that. But I think it's probably a pretty better situation there, rather than letting this thing just hang fire and having a bunch of damage actions after the fact to try to resolve it with greater clarity earlier on. And so what generally happens, I think, is I've kind of switched to this view more regularly, is that I think in the absence of special damages, rather than trying to do the whole stuff associated with the class action, I think a fine based on a loose proxy, 5% of revenues or something like that, will get you the needed deterrent effect in most of these cases with some situation, rather than having these class actions, which themselves can be massive distractions, in which if you actually look at some of the numbers, given the fact that you now get the very clever expert witnesses, the damage levels turn out to be systematically too high. And so this is an argument for saying, in effect, you want to be careful with injunctions on how you frame them. But in general, an administrative solution may not be bad if it turns out that you've got these diffuse kinds of injuries, and that the class action, I think, wears less well than I thought it did even 5 or 10 years ago. I may be wrong about this. It's an empirical question, but that's my initial estimation. So I'll stop there.
Right. Thank you so much, Richard, for these great comments, and also the link between the precautionary principle and antitrust matters. I was wondering, do you see a trade-off, or at least a shift, not only in antitrust, but more generally in terms of regulations, between adjudication and regulation, the need for governments or for agencies to regulate ex ante in order to avoid to adjudicate or to avoid prosecutions? You see what I mean? Like, because adjudications take too long, and also there's a lot of uncertainties for the government to win.
It's okay. This is a very tricky question. It goes back a long time ago.
Right.
The first case that involved Illinois BRIC was not an antitrust case. It was a standard rate regulation case, in which the question that you had to ask is if there was an overcharge, a permissive excessive rate by the regulator, was the refund given only to the direct purchasers on the one hand, or did they have to essentially turn some of it over to people downstream? And what Justice Holmes said was, look, I believe in the theory of proximate cause. I'm only going to allow one plaintiff. I'm not going to allow anything to go further on downstream. You guys can adjust that by contract if you want, so you get single remedies. And I tend to think that all the rules that kind of try to force people into single remedial situations are by and large very, very good, because what happens is they simplify the litigation, they get it done more quickly and so forth. And in effect, everybody else can sort of protect themselves in other kinds of ways. They're not wrongdoers. I don't like the large class action. And I think the Supreme Court's cutting back on Illinois BRIC. What really worries me about the current situation is that the way the double remedy system seems to work is as follows. First, what we do is we have some kind of FDA or DOJ determination, which establishes, say, cartel illegality. You may or may not have a fine, but then what happens is, given the offensive use of res judicata, what you do is a private party goes after these particular parties. It says, look, you can't relitigate the question of the violation. The only thing that you can relitigate at this particular point now is the level of the damages. So what you do is you get double level enforcement.
Right.
And what's happening with the administrative stuff is something like fashion originators is you go in fairly early on with the process. The only thing you're speaking is injunctive relief to clarify the situation. And now it's quite understood that the antitrust stuff has both the legal enforcement, the illegality function, the fine function, and then the private action function. I think if you put the three things together, there's a serious risk of over-enforcement. And of course, given the fact that some of the things that we now call offenses are what I would never want to call an offense because of the change in the substantive law, you get an expansion of substantive law and an expansive remedial stuff, which could have very toxic effects on the long-term operation of the system. So if you go back to the 1536 solution for public nuisances, understand that it carries over to every known area that I've ever done with traffic accident, consumer fraud cases, misrepresentation cases, antitrust cases of one kind or another. I think that that's probably on balance the better solution. Earlier on in the discussion, of some of you may not have been here because of this fragmented conference, Scott Hempel, he who believes all too much in the incipient merger doctrine, of one form or another. He said, I hope that this panel is not going to be stacked in favor of ex post litigation as opposed to ex ante stuff. I don't think that it is. I think probably a little bit more on the ex ante side than I am on the ex post side. I'm not quite sure about that. And then you take people like Dan Rubenfeld, whose substantive disagreements with me are there. I mean, we're not 100% close, but in the sort of, we each understand what the other one's saying kind of disagreements and so forth. And he comes out exactly the opposite way. And the long-term lesson you always learn from this is that people have perfect agreement on substantive issues. They often divide very deeply on remedial questions because they're extremely difficult to resolve. And in fact, to talk about something that brings with what David had said, you try to go into a FRAND negotiation, you're talking about trying to get a good faith solution. You're trying to go into one of these courts of equity, and what you say is the remedy is the result of the sound discretion of the trial judge. And that kind of looks really terrible, like a hop-out. You don't actually look at what really good judges do with those particular standards, and it's amazing how smart they are. That is, I mean, it's a degree of discretion, but if you keep in mind that you're trying to minimize the sum of over and under enforcement in areas, and every time you push in one direction, you want a reason to go that way, and every time you push in the other direction, you'd like to have an opposite reason, the process itself, if you do it incrementally, turns out to be better than the abstract statement of the principle work, which is why it is that, at least in contexts where you're dealing with friends, good faith negotiations work, right? Because of all the other constraints. And in fact, David, when I wrote my paper with Neruzzi, we did this stuff, and I then gave I wrote the part on labor negotiation, which is why it is when you're talking about antagonistic parties, i.e. employers and unions forced together by law, not by common concern, the good faith principle breaks down. It simply cannot do the kinds of things that you want, and it has to be contextual. There are other cases where it works extremely well in contract stuff, mainly when there's an incomplete agreement. You imply those terms which are necessary to give some kind of competitive balance to the overall situation. And if you go back to Wood against Lady Duff Gordon and take it forward from there, it's again how good the legal results turn out to be when you get judges who are understanding that we do not wish to read contractual agreements to create fatal imbalances between the parties. Mutual gain is the objective, and you reconstruct the contract, and the terms that they imply are remarkably consistent, and they're the same from Roman law forward to the present time with respect to many kinds of standard time forms of contract. They just don't change.
That's the hardbacks to the evolutionary hypothesis, the efficiency hypothesis of the common law process, right?
Well, actually, no, it's not.
That right.
I'll tell you why.
Okay.
The common law process depends on who the judges are. And so if you got Skelly right, and you're trying to talk about efficiency and contractual negotiations, he's going to write cases like Javins and on the leases and Williams and Walker Thomas furniture, respect the contract, all the stuff he doesn't understand at all. The reason the Roman law worked is it wasn't made by judges. The Roman law principles were done by jurists. Some of whom were general, some of whom had practical experiences and so forth, but it is not a judicially driven system, so you don't get all the public choice analysis for and against how judges start to make their thing. It was done by people who just had intellectual interest in it, and the utter miracle of this particular system is, you look at it 2,000 years later and say, how could these guys have been so smart? Because they made all the right kind of general judgments. They made mistakes in individual cases, of course, just the way we do. But when you teach this system, as I do all the time, I said, look, assume you have a Cautionary framework in this world, which I'm going to define in one sentence, namely that the way in which you increase social welfare is to reduce transactions cost, right? So that more faithful bargains start to take place. And if you apply that to the Roman systems that they used, it gives a very powerful explanation of rule after rule and case after case, where the conditions were not the same. So you could not have fungible assets behind trusts in Rome, right? You didn't have stock markets and so on. And all their close substitutes took into account those sort of situations and did it well. So, I mean, this is not a story about judicial stuff. It's a story about rules. Now, the 19th century English judges, they were amazingly good. And so were the best American judges. Take the American judges in the last 20 years, not so good. In some cases, really good in other cases. I think what you'd say about current judges, my view is that the dispersion in quality from top to bottom, even on the same court, the scale goes from 1 to 10, the capability of judges go from 1 to 10. And that complicates the analysis enormously, particularly for the Priest-Klein hypothesis. Are you nodding or disapproving, Dave?
Any other questions for Richard?
Well, I really managed to rile everybody up.